It's March 5th, 2026, and this is the Court Gallery. That's right, ladies and gentlemen, we're getting started. It's just a minute early. Ladies and gentlemen, we're staying in Michigan for most of the day today with a little bit of Washington in the mix from Battleground, not from Olympia this time. So buckle up. We got a lady who's really mad at her husband for cheating on her, and she's using the car to take it out on him. We got people who are lying to the judges left and right, and judges calling people out for most of the night. So I hope you enjoy, because as always, it all starts right now.
This is 261-469-FH, People of the State of Michigan versus Tara Bentley. Miss Bentley, you made it.
I am so sorry. I am so sorry.
Okay, you're here.
I would never miss court. I'm sorry, I'm still shaking because I was so scared.
You're here. Yeah, take a deep breath. You're all right. Okay, good. All right, relax. You're okay. Ms. Bentley is here along with her attorney, Mr. Robert Hinojosa. The people are here and represented by their elected prosecutor, Mr. Scott Kerner. I've received some paperwork that indicates we're going to attempt a plea. That paperwork includes an advice of rights form. Looks like that's signed by Ms. Bentley. A plea agreement sheet signed by the attorneys, Ms. Bentley. And then Mr. Hinojosa, an amended information.
Your Honor, I would acknowledge receipt of that amended information and waive its formal reason.
And you got it there handy so Ms. Bentley can refer to it if she needs to during the course of the proceedings?
We have it in front of us, Your Honor.
Perfect. Thank you. Ms. Bentley, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. You may put your hand down. Ms. Bentley, are you on probation or parole in this court or any other court?
No, sir.
Other than the charges that bring us together today, do you have charges pending anywhere else? No?
No, sir.
Thank you. No, it's okay. I just didn't hear you. Mr. Kerner, do you have terms for us?
Yes, Your Honor. The defendant will plead guilty to count 2 of the amended information, operating while intoxicated, third offense, and count 4, malicious destruction of property, 200 to 1,000. Defendant agrees to pay restitution in the amount of $1,097. There is no objection to treatment court if eligible and accepted. The prosecutor agrees to dismiss counts 1 and count 3. The estimated sentencing guidelines are 10 to 23 months.
Thank you, Mr. Hinojosa. Is that your understanding of the terms?
That is my understanding, Your Honor.
Thank you. Mr. Kerner, would you read that count into the record, please, or both counts, rather?
In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and location described above, the defendant did, in count 2, operating while intoxicated, impaired, third or subsequent offense notice, did operate a vehicle upon a highway, Miller Road, while having alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to MCL 257-6251. This is a misdemeanor, punishable up to 93 days and or $100 to $500 and 300 hours of community service, rehabilitative programs, vehicle mobilization, mandatory the prior, cost of prosecution, reimbursement of government agency response and expenses for prosecuting the defendant. Third or subsequent offense notice, felony. Take notice that the defendant was previously convicted of operating while impaired on May 11th, 2009 in the 66th District Court and of operating while impaired on about May 9th, 2014 in the 66th District Court. Therefore, upon conviction, the defendant will be subject to an enhanced sentence under MCL 257-6259 or MCL 257-62511 and vehicle forfeiture under MCL 257-625N. This is a felony punishable up to $500, $5,000, $500 to $5,000, and either 1 to 5 years of probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days community service, rehabilitative programs, cost of prosecution, reimbursement of government emergency responses and expenses for prosecuting defendant, mandatory vehicle immobilization not less than 1 year or more than 3 years, unless the vehicle is ordered forfeited under MCL 257-625N. A term of imprisonment must not be suspended unless the defendant agrees to participate in a specialty court program and successfully completes the program. This is against the peace and dignity of the state of Michigan.
Thank you very much, Mr. Kerner. Ms. Bentley, we've got a lot to go through. Are you ready?
Yes, sir.
Okay. I'm told first that you're willing to plead guilty to operating while intoxicated third offense. Is that correct?
Correct.
Now, normally that would just be a misdemeanor punishable by up to 93 days in the county jail, but I'm told that you were twice previously convicted of operating under the influence type offenses, which would take the mandatory maximum from 93 days in the county jail up to 5 years imprisonment. Is that your understanding?
Mm-hmm. Yes, sir.
You got to speak up so we can
Yes,
hear
sir.
you. All right. Now, other consequences come with that as well. There'll be driver's license sanctions based on your master driving record. I don't know what's on your record, so I don't know what the status of your license is, but this will affect it. Do you understand that?
Yes, sir.
Also, you'll be subject to vehicle immobilization. That means that the vehicle that you were driving when you were involved in the offense, it'll be locked up. Either, go ahead.
That vehicle is no longer mine.
No longer yours?
Yeah.
What'd you do with it?
My soon-to-be ex-husband, he took it over.
He took it over. Well, we can deal with that later. There are exceptions. If it looks like you disingenuously transferred it to avoid immobilization, we can get it anyway. And there are exceptions, though. Your attorney knows what those exceptions are, but I'm required to advise you that immobilization is on the table. Do you understand that?
Yes, sir.
All right. Mr. Kerner estimates your sentencing guidelines for this conviction to be 10 to 23 months incarcerated. Did you hear him say that?
Yes, sir.
Did you hear him use the word estimate when he was talking about your sentencing guidelines?
Yes, sir.
That's important because the court will score the accurate sentencing guidelines as we get close to your sentence date. My point, Ms. Bentley, is that if the court scores the sentencing guidelines higher or differently than 10 to 23, we're going to use the latter guidelines, the guidelines that the court scored, and you wouldn't be able to withdraw your plea on that issue. Do you understand that?
Yes, sir.
Does that make sense to you?
Yes, sir.
I'm also told you're willing to plead guilty to count. Where is that count? Actually, count 2 is operating while intoxicated. Count 1 is malicious destruction of property over 1,000, less than 2,000. Is that your understanding? No, that is 2. I'm sorry. Count 4 is the additional charge. I got it. You're also going to plead guilty to count 4, right? The added count 4, which made it the amended information. That's a misdemeanor, a malicious destruction of property. Is that your understanding?
Yes, sir.
That's a misdemeanor punishable by up to 1 year in a county jail. Is that your understanding?
Yes, sir.
Forget about count 1, 2, and 3. Also, I'm told you're willing to pay as a part of this plea deal to pay $1,097 in restitution. Correct?
Yes.
Finally, the people do not object to you coming into one of Shiawassee County's treatment courts. Is that your understanding?
I'm sorry, say that one more time.
Okay. It's my understanding, I want to see if it's yours too, that the people do not object to you becoming a participant in one of its treatment courts.
Yes.
That doesn't mean that you automatically come into a treatment court. That just means that the people don't object. The decision still lies with me as the presiding judge as to whether or not you'll come in. Do you understand that?
Yes, sir.
And I don't know anything about you. I know you're a little bit late today. I don't hold that against you because you are here. But I don't know anything about this offense. I don't know anything about your substance abuse history. I just don't know. I can't tell you whether or not you'll come into a treatment court today because I don't prejudge people or cases. Does that make sense to you?
Yes, sir.
I will authorize a screening, and my team will come over and screen you and determine whether or not you're eligible. And then I'll make a decision, but I'll hear from your attorney, I'll hear from the prosecutor, I'll hear from you too before that decision is made. Do you understand?
Yes, sir.
Does that seem like a fair process to you?
Sir.
Okay, do you have any questions?
No, sir.
I'll have to tell you though, if the court decides for whatever reason that you will not come into a treatment court, you wouldn't be able to withdraw your plea. Do you understand?
Yes, sir.
Okay, understand everything we've talked about. Do you have any questions?
No, sir.
Other than what was placed on the record here over the last few minutes, have anybody made you any promises to get you to plead guilty today?
No, sir.
Thank you. Mr. Hinojosa, are you aware of any promises not placed on the record?
I'm not, Your Honor.
Mr. Kerner?
No, Your Honor.
Ms. Bentley, has anybody threatened you or any members of your family to get you to plead guilty today?
No, sir.
Are you pleading to operate while intoxicated, third offense, and malicious destruction of property under 100? Yeah, more than 200, but less than 1,000 because you are guilty of those offenses?
Yes, sir.
Now, has your attorney, Mr. Hinojosa, left the final decision as to whether or not to plead guilty up to you?
Yes, sir.
Has he talked to you about the different means you have to dispose of these cases? Has he talked to you about that? Different ways to take care of the case? Like have a trial, enter a plea?
Oh, yes, yes, sir.
Yeah, has he explained to you your right to a jury trial and all that entails?
Yes, yes,
Have you concluded, Ms. Bentley, that this plea offer is in your own best personal interest?
I believe, yes, sir.
Okay. Do you understand, Ms. Bentley, that once the court accepts your plea and finds you guilty, you give up or you waive your automatic right to appeal? Do you understand that?
Yes, sir.
If you wanted to appeal these proceedings, I mean, it's fine, but you would have to go to another court and ask them for permission to appeal. Not this court, but another court. Do you understand that?
Yes, sir.
Do you have any questions about that?
No, sir.
All right. You signed an advice rights form, it appears, because I have that form and I see a printed name, Tara Bentley, and there's a signature above it. Is that your signature?
Yes, sir.
Did you read all the rights on that form before you signed it? And before you signed it, did your attorney, Mr. Hinojosa, make himself available to you to answer any questions you might have or address any concerns you may have about those rights?
Yes, sir.
Finally, Ms. Bentley, before you signed the advice or rights form, did you, in your mind, knowingly and willingly waive those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Do you have any questions about anything at all regarding the plea?
No, sir.
Are you ready to move forward?
Yes, sir.
Very well, then. How do you plead to count 2 of the amended information operating while intoxicated?
Guilty.
How do you plead to count 4 of the amended information, malicious destruction of property, over 200, less than 1,000?
Guilty.
Thank you. Is it true that back on May 11th, 2009, in the 66th District Court, you were convicted of impaired driving?
Yes, yes,
Is it
sir.
also true that, I'm sorry, I didn't mean to talk over you.
Oh, no, I said yes, sir.
Is it also true that on May 19th of the year 2014, you were also convicted of impaired driving in the 66th District Court?
Yes, sir.
If we go back to the time and date set forth in the amended information, Ms. Bentley, what happened on September 15th of the year 2025 that makes you guilty of these crimes? What did you do?
I was going through a lot. I had just lost my daughter a couple
Okay,
months.
I don't care about
You want me all to know that? Okay.
Well, hold on, please stop. I'm not interested in the buildup or what was going on before. I just want to know what facts you performed that makes you guilty of the crime. The circumstances surround it, I'll be happy to hear that at sentencing. That's all totally appropriate for then. But today I just need what exactly happened.
Okay, I'm sorry.
No, don't be sorry. You probably haven't done this a whole lot, so it's all right.
I took my vehicle that I had at the time and slammed it into my husband's work vehicle.
Okay, I just need you into the microphone. You got to speak up loud.
I took my vehicle and slammed it in the side of my husband's work vehicle.
Now, what happened before that?
I was drinking.
All right, there you go.
Alcohol.
So you consumed some alcohol on that date?
Yes, sir.
Where were you consuming alcohol?
In my vehicle.
You were in your vehicle drinking?
Yes. On the road. I picked it up from the store and was heading home when I got the phone call
What phone call?
about my husband having an affair.
Oh, so you're mad at your husband?
Yeah.
Okay, so you're drinking.
Yes.
I mean, what were you drinking?
Shots.
Shots? What shots of what?
They're like cherry limeades or whatever. I think Smirnoff makes them.
Okay. And so when you're drinking while you're driving?
Yes.
Is that, just be honest, that's okay.
I am. Yes, sir.
And you were operating your motor vehicle, where were you?
On my road.
Well, okay, I don't know where your road is.
Miller Road in Bancroft.
Then is that a public highway or a road generally accessible to motor vehicles?
Yes, sir.
Were you intoxicated?
Yes, sir.
And while you were operating your motor vehicle, you were intoxicated and you were continuing to be intoxicated because you were taking shots?
Yes, sir.
And then you drove to where your husband's vehicle was?
Yeah, at our house.
At your house?
Yes.
All right. And your house in Lennon?
No, Bancroft.
Bancroft.
Yep.
Okay.
Miller Road.
And you saw his vehicle?
Yeah, he was in the side yard and I seen his vehicle and I just went for it.
Hold on, let's back up. So you saw his vehicle
Yes.
and he wasn't in his vehicle?
No.
And so you rammed it with your vehicle?
Yes, sir.
You do that on purpose
Yes, sir.
because you were mad?
Yeah.
But it was willful, malicious?
The alcohol probably didn't help the situation.
But you did that willfully and maliciously, right? Because you're mad because he was having an affair?
Yes, sir.
I mean, that's not okay, but that's what happened, right?
Yes, sir.
And then you smashed into his vehicle. Did you cause damage to his vehicle?
Yes, sir.
Was it over $200?
Yes, sir.
Okay. And Mr. Hinojosa, was there a breath or a blood test?
Your Honor, I believe there was an alcohol test in this matter.
What was it?
0.179 grams per 100 milliliters of blood, Your Honor.
All right. So if that's correct, you were pre-intoxicated, correct?
Yes, sir.
And this occurred within Shiawassee County, Bancroft area?
Yes, sir.
Mr. Kerner?
We have factual, Your Honor.
Do you agree with Mr. Kerner, Mr. Hinojosa?
I do agree with Mr. Kerner, Your Honor.
And Mr. Hinojosa, do you believe the court's complied with the guilty plea provisions of Michigan Court Rule 6.302, subsections B through D of that court rule?
Court has, Your Honor.
Mr. Kerner, do you concur with Mr. Hinojosa on that point?
I do.
I do. I'm sorry.
I do.
All right. Ms. Bentley, the court does find you guilty. The court agrees with the lawyers that your plea is understanding, voluntary, and accurate. Your conviction is now made a part of the record of this court. Let's check in with Mr. Schmidt and see if we have a sentence date.
Yes, sir. It's going to be April 17th, 2026, 8:30 a.m.
Mr. Hinojosa is already going to be here on that date, so I'll look forward to seeing him again on another matter. Would you like to address bond, Mr. Hinojosa?
Yes, Your Honor, thank you. Ms. Bentley has remained gainfully employed. She is working hard at her sobriety. She indicated to me that she's about to celebrate 6 months of sobriety. She's very remorseful for what she has done here, looking forward to, we've completed her application for a treatment court. She is looking forward to potentially getting some services. I'd ask that you continue bond in the interim.
Mr. Kerner.
I don't know if she's a member of pretrial services or if she's been tested. That would be my only, if she's been undergoing testing during this time, I don't know.
Was there anything else?
Ms. Bentley indicates that she does go to recovery pathways.
Oh, good for you. All right.
I started there in November.
Good. I'm glad you're doing that. The condition of your bond is you not use alcohol and drugs, correct?
Yes, sir.
If we tested you, would you be clean?
Yes, sir.
Mr. Hinojosa, your last guy was clean. Mr. Green, by the way.
Thank you.
Can you go for 2?
Your Honor, so the court is aware Ms. Bentley has indicated that she has a medical marijuana.
Okay. All right. I'd still like to get you tested to see what you have in you in terms of substance abuse. You have to know, though, if you're using marijuana with the medical marijuana card, I cannot bring you into drug court. I cannot. Pardon me?
I can.
You could do whatever you want. Excuse me, don't talk over me. I can't tell you not to use marijuana with a medical marijuana card, nor would I want to. But federal money funds drug court, and federally, marijuana is still illegal. So if you're using a medical marijuana card, if you're using marijuana pursuant to Medical Marijuana Act, we're not interested. We can't have you in the program. So you'll have to decide what you want to do. Do you understand?
Yes, sir.
In fact, I would say that if you're positive for marijuana, your sentence date, I will decline to bring you into the program.
Okay. Yes, sir.
Are you getting what I'm putting down?
Yeah. I need to be clean by the 17th.
That's exactly right.
Yes, sir.
Are you a heavy user?
No.
Okay. Well, you got to be clean. You just have to be, or we can't
I'm
bring
done.
you in the program. Done. I mean, there has to be other ways to medicate whatever your chronic condition is. Okay.
Sir. Yep.
But that's up to you. I can't force you one way or another.
Understand. I understand.
But let's get you tested anyway, see what's going on. If it's marijuana, and did you bring your card with you?
It's downstairs.
Okay, good. I'll need you to show that to the treatment person.
Okay.
I'm assuming that it's just marijuana and you have a card, there's no alcohol, nothing else in your system, then I will continue your bond. But you've got work to do before our sentence date. The first is, well, your attorney's going to give you an order. You still have to report to the county jail. The only reason for that visit, was for you to leave a DNA sample, be a mouth swab. You do that for us?
Yes, sir.
Okay, that's it. That's it. Then you'll need to meet with the Michigan Department of Corrections. Their job is to prepare a pre-sentence investigation report. Be honest and forthright with the agent. Also, you'll be meeting with members of my treatment team so that they can determine your eligibility to the program. Be honest and forthright with them too. Can you do those things for us?
Yes, sir.
Any questions?
No, sir.
Okay. Ms. Garrity is here. He's waiting for you. Anything else, Mr. Hinojosa?
Oh my God, thank you.
Mr. Kerner.
No, Your Honor.
All right, Ms. Bentley, good luck. Thank you. You're welcome.
Next matter is State of Michigan versus Lori Burgraff, file 26-44261-FD, set for sentencing. Do we have Ms. Burgraff with us?
Yes, sir.
All right, I do see you now. Mr. Brown, is this your matter?
It is, Your Honor.
All right, looks like we were here for a plea, on January the 23rd. There was a plea to drunk driving first offense, dismissal of the drunk driving third offense. Sentencing was set for today to allow a substance abuse assessment. I have received an assessment from Catholic Human Services. It's like the appointment date was set as February the 20th. It's filed by Charles Heidema. Recommends alcohol highway safety education class and a victim impact panel. Mr. Fortier, have you received a copy of that report as well?
Yes, Judge.
All right. Ms. Burgraff, I'm going to hear from both of the attorneys as to what they think should happen in this case. And then before I make a decision, I'm going to ask you if you have anything to tell me about this case and what your recommendations are. So please listen carefully to the attorneys. I'll start with Mr. Fortier.
So, Judge, in reviewing the assessment, I honestly don't think that she was upfront with the evaluator. The main thing I want to point out is, let's see, that would be on page 3 of 6. At the bottom where it says legal status, she reports no other offenses reported over lifetime, which is patently not true. In 1994, she was convicted of DUI in Florida. In 1996, she was convicted of DUI in Florida. In 2005, she was convicted in DUI in Florida. In 1992, she was convicted of an attempted possession of a weapon in Florida. And then in 1998, had a possession of cocaine charge that she was convicted of. And also a 2006 battery in Florida. So this is definitely not her first OWI. She didn't even tell her assessor that, which I believe would have definitely altered the recommendations. I understand that those convictions are, 1994, 96, 2005, so on and so forth, but it's just not true. The other thing that it is really hard to believe is that she scored a 0 on her simple screening instrument, indicating a need for brief intervention or full intervention. That's just wildly, it's just unimaginable almost that a person with, 4 prior OWIs, that's making it a 5th, would have no need for intervention. So I think, honestly, what was contained within the evaluation, I don't even know if we can give it much credit, regardless of who it comes from, because she just wasn't even honest with who she talked to. I think based on the circumstances, she was given this plea mainly because her blood alcohol level wasn't exceedingly high. I think it was a 0.088 and a 0.092. But the fact remains is that she, over the course of the last 30 years, has shown that she has a problem with consuming alcohol and driving, putting other people at risk, putting herself at risk. I think it's time for the court to send a message that we're not going to tolerate that kind of behavior. We're not going to let it slide. And I think she should be put in jail. I would leave the amount up to the court, amount of time up to the court if the court does choose to follow that recommendation. But I would definitely ask for jail. I would ask for probation. All the recommended or the standard courses, so the victim impact panel, the alcohol highway safety class. I don't know if there was a reimbursement request. So if you give me a moment, I can look for that. But then it's $200 to the Michigan State Police. That's what the reimbursement request is for. I believe that's it.
All right. Thank you, Mr. Portier. Mr. Brown, allocution.
Your Honor, with regard to the assessment and the simple screening where it stated that she doesn't really need full intervention, but relatively brief intervention. Again, I don't believe that she has necessarily done this over the course of 20 or 30 years. She may have had a significant number of convictions 20 or 30 years ago, but there is also a very, very significant gap. And again, this is a very low level from what we're used to seeing a lot of times. But I think that maybe she had a bad day, maybe she made a bad judgment, but I don't think this is something that needs a full intervention. And I don't think that the evaluator saw it that way either. But regardless, it is something, again, it's not a course of behavior. It's a lapse of judgment from behavior that happened 2 or 3 decades ago. So I would ask the court to take that into consideration.
Thank you. Ms. Berggraf, is there anything that you want to tell me before I decide what to do?
Yes, sir. When I was doing the evaluation, I did not hear him say something about through the lifetime. I just was thinking about the charges of being my first, and I have not gotten any trouble in years. It was a bad decision. I was stuck in a snowstorm, and I had called AAA to come get me, and I was waiting hours and hours, and I had taken the drink that I was taking home. I wasn't drinking and driving. I have not gotten in any trouble in so long, and I am so sorry that I made a bad judgment. I don't want to go to jail. I'm here, I have a dog, and I don't have means to, I just go to work and I come home and I don't get in any trouble. And I'm so sorry that I made a mistake. But I'm going to be 65 and I'm just sorry. I'm like freaking out right now.
Ms. Berggraf, your attorney is a very good attorney, so he knows how to argue things. But I'm not buying that this was a mistake. Even before I heard from the prosecutor, I looked at even before I knew that you had these prior convictions, I looked at your assessment and you said you had one drink that you took from your employment and we're going to drive home and drink it at home, and that your blood alcohol level was a 0.088. You can't get to a 0.088 on one drink. I don't care what kind of proof vodka you're drinking. You can't get there on 6 or 8 or 10 ounces of alcohol. It's unimaginable to me. And now when I hear that you've got 3, 4 prior convictions for drunk driving, admittedly, they're 30 years old, and the last one's 20 years old now. I get that. But for you to tell me that you got there on one drink. Number
was-
one, and this is my time. I'll give you a
Okay, I'm
chance to talk
sorry.
to me. Just slow down. So I don't believe that. Number two, I don't believe that you took home a drink to just, who takes home a drink? And then you can't have open intoxicants in a car. And then to have 4 drunk drivings on top of it. Are you out of your mind? That boggles my mind.
I
Go ahead.
understand what you're saying. I was working that day and she gave me a drink that had closed container, and I was taking that, my shift drink, basically home with me. It was strong, and I drank it in the car. I understand what you're saying, and it was the biggest mistake in my life. I understand. I have not gotten in any trouble, sir. I have not gotten in any trouble, and I made this big, huge mistake.
Why are you still drinking at all? Why do you think it's okay for you to have alcohol?
I have not drank since that day, sir. I swear to God.
Why after 4 drunk drivings would you have alcohol at all? You call it a shift drink. This is the thing that I do on a regular basis. Why would you do that?
I know. I had a bad day. I was taking it home. It was a terrible mistake.
A mistake is something that you don't recognize. You don't understand what you're doing. You make a mistake when you don't understand or know what you're doing. After 4 drinking and driving related offenses, that was not a mistake. That was an intentional act.
I understand what you're saying. I don't know how to explain it. It was the worst decision of my right now that I could think about. And I don't ever want to have another drink in my life. I am trying to have a good home, and stay out of trouble. And when I took that assessment, I was going on the fact of what I've been doing with my life and changed it around.
Here's my problem, Ms. Burgraff. Today is a bad day for you because you got caught. That day was a bad day for you because you got caught. What it appears to me is that you're back working in an environment where alcohol is accepted by everybody there, and it's okay to drink. It's not okay for you to be there. It's not okay for you to drink. You are an alcoholic. You will be for the rest of your life. If you haven't figured that out by now, I do not know what you've been doing with your life. 4 different drunk driving offenses over the course of 10 years, even if they were at the earliest 20 years ago, should still tell you that you have a lifelong problem with alcohol. You can't be around it. You can't use it. You can't allow yourself to get in these situations, because I'm doing what every sane judge in the world will do, which is say, I've got a drunk driver waiting to kill somebody driving around on the roads, because you can't figure out how to leave alcohol alone. My worst nightmare is sentencing somebody like you, having you get out of jail and go out and kill somebody because you're drunk again. Do you understand that?
I do, sir. I understand it.
Well, I sure wish you'd have picked up on that 6 months ago. We wouldn't be here today. Is there anything else that you want to tell me before I decide what to do with you?
Don't give me jail time, sir. I will do whatever you want. I got this job because can be part-time. I collect Social Security. It does not pay enough for my money, for my rent and everything. And that's the reason why I got this particular job, because it can be part-time and you can make money.
Where do you work at?
I'm working, oh my God, I work at the Iron Pig at the South. I also work at Amazon in the warehouse, sorting the packages and trying to pick up shifts there. I just haven't worked in the last few weeks. I've been sick with the influenza A.
So how many shifts do you pick up at the Iron Pig and how many shifts do you pick up at Amazon?
I have to do a minimum at Amazon of 4 hours a week. I just picked up 2 shifts next week because you pick them up at noon every day. And then I'm only working at the other job. They got me down for 3 days a week. I was working more, but they got me down to 3 days.
Are you telling me you can't find something at Lowe's or Home Depot or a hardware store?
Oh, I will, sir.
Amazon?
I will. I will quit that job and I will just go to Amazon and I will try to pick up another job if I have to. If that's what.
Well, here's what we're going to do, Ms. Burdraff. You're going to go back to Catholic Human Services and you are going to give them an entire rundown on your criminal history.
Yes, sir.
I'm going to have my staff contact Catholic Human Services and send them a copy of your criminal history. And then you are going to be completely honest with them about how much you drink, how often you drink, because I can't believe that this is the only time that you brought something home from the Iron Pig. And then if you can convince me that you are done with the Iron Pig and you're picking up shifts at other places, I might think about not putting you in jail. So I'm going to give you 30 days to do that. We're going to come back here. Actually, I'll give you a little more than that because it might take you that long to get back in. We got time. April 23rd.
Yes, we do.
April 23rd in the afternoon is when we're going to come back. That
Okay.
gives you a month and a half. Almost 4 weeks in April and 3 weeks now in March. So you got 7 weeks. Convince
Can you give me
me
the
I
date?
don't. April 23rd, 1:30. Convince me I don't need to put you in jail. That means get rid of the Iron Pig, get a different job, get your substance abuse assessment done. Show me that you can be the good citizen that you should be right by now. Do you understand that?
Yes, sir. I will
All
put my
right.
notice in.
I'll see you on the 23rd, 1:30.
I
That's all
have
for
it.
today.
Thank you, sir.
As soon as she joins us, I'll jump right in.
And I can step away if I need to ask for some support with the. There we go.
All right. Ms. Taylor, can you hear the court, ma'am?
Yes.
Can you state your name and date of birth, please, for the record?
Roberta Taylor, 79.
Ms. Taylor, you're before the court on 2 charges that are pending charges of theft in the 3rd degree. That is a gross misdemeanor, ma'am, subject to 364 days in jail and a $5,000 fine. The first is from August 2nd, 2024 in the city of Battleground. I did review the associated police reports for that case and I did find probable cause. The second is from May 12th, 2024 in the city of Battleground. I I did review the associated police reports with that case. I also did find probable cause. Your final case is a probation case that you were on in the city of Battleground as well. Your attorney, Mr. Campbell, is with us here in the courtroom. Go ahead, Mr. Campbell.
Your Honor, we just enter not guilty pleas to all pretrial matters and denials on any allegations of PV violations. I did note that there was a 25 conviction. I think that I haven't completely reviewed the material, so I'm not sure if that conviction dates after the sentencing in the 24 matter, but I think it's possible that that's the case. But ultimately, where we're at is we're just asking for a set over likely to March 19th, but somewhat depending on Your Honor's decisions on release conditions once we get to that point.
Is she being held on other matters?
I don't believe so. Do you have better?
It was an active warrant out of Cowlitz County Superior Court.
I'm not sure if that's a warrant that's been served, if it's transportable, or do you know what the underlying charge is?
I think it's a post-conviction issue. It looks like it's on that 2025 controlled substance.
Yeah, they're probably not.
There's probably not DOC on that, so I imagine that warrant's not going to be served if I had to guess, but I can't know.
City's position on Ms. Taylor.
Your Honor, Ms. Taylor has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 warrants out of our court. It appears 9 warrants out of our court, and another 10 to 12 out of other courts. The city's asking for bail in the amount of $2,000.
Mr. Campbell?
Your Honor, that's a reasonable request. I think I would give the court some update on Ms. Taylor's circumstances as she's describing them to me and make a pitch for recognizance because she can't bail out. But ultimately, Ms. Taylor is a 25-year Clark County resident. These are property crimes and I think a possession controlled substance allegation on the underlying PV and maybe another count there that's conviction. But she's recently gotten employed. She's missed work at Bimart, so it's possible that she's going to lose that position. She doesn't have meaningful family connections in Clark County currently, but she does have an address in Washougal that she's provided to counsel. She indicates to me she's got the lawful ability to drive. I haven't been able to verify that, but she's also provided me a phone number and an email address. I think the biggest circumstances over a history of lengthy amounts of what appears to be potentially substance use disorder related history and indigence is that she does have a driver's license, and she tells me she has a vehicle with which to get to court, which is a change in circumstances from her historically. If Your Honor imposes bail, we'd ask it be put on one case in the total amount of $500. I still don't think that she will be able to post, but that seems more commensurate. Not that it's a completely unreasonable request. I'm not making that argument by counsel, but defense's position is that's a reasonable amount for her circumstances to ensure future court appearances in these matters, even considering the dated nature. I think the last warrant was issued in October of 2025 in our matters. And there was not a DOC hold that I could see or a hold in the Cowlitz matter on the Clark County jail roster when I reviewed this morning. So I think she would be released if Your Honor was to put her on intensive pretrial supervision.
She won't show up. She never has. She's been appearing in front of me now for years, and she doesn't come unless I issue warrants. And I've issued lots of warrants for Ms. Taylor. And if she has a vehicle and could have driven herself to court, I don't think that's better. I think that's probably worse. I was looking to see, she's been cited and even on this probation case multiple times by the court and not the district court and never shown up, 2 times at least. She was sentenced on this matter in April of 2024. And so at least according to the DCH from Ms. Taylor, if she was sentenced in April of 2024, it means that she was at least allegedly engaging in new criminal conduct multiple times since the time of her sentencing in April, and on May 12, 2024, on August 2nd, 2024, with a conviction on March 29th, 2025, and another pending charge from just 3 months ago in December of 2025. So I'm going to find that Ms. Taylor's not coming back unless there's a warrant, or it is going to issue a warrant. It's the only way to assure that Ms. Taylor will appear. I'm gonna put bail in the amount of $1,000. And that is going to be on the probation case. That's the oldest in time charge. That's also the one that allegedly she's already committed a new crime since that time and has 3 other pending charges. I find that Ms. Taylor is a danger to the community with, again, multiple property-related theft charges. To that end, and the fact that there is bail, what date do you want me to set this to, Mr. Campbell?
March 19th, Your Honor. And it's somewhat of a hyper-technical request, but putting bail on the probation matter does leave us at a 90-day position on Speedy on the underlying new law violation. So I would ask that we put it on the pretrial matters, but I understand your ruling if you don't do that.
No.
Yes, Your Honor.
Okay, so is it March 16th?
The 19th, I think, is
March 19th. My
yes.
apologies.
Sorry.
All right, Ms. Taylor, we're going to see you back on March 19th, 2026. If you do post bail, that's at 10 a.m. If you are still in custody, you'll be brought over to appear at that time. The victims of the thefts, I think I need to put NCOs in place on those.
And I apologize, Judge. I didn't review the PC statements sufficient to be able to tell you what those are.
Probably put NCOs in place before, but because there's been so many warrants, maybe she's never appeared on some of these cases. Let's see. Specifically, store, and in the other matter. All right, Ms. Taylor, if you do post bail, your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to have any contact with the Pacifically store, Walmart store, and if you do post bail, you're on intensive pretrial release with Clark County pretrial release. Do you have any questions, ma'am?
No.
Very much. That concludes your hearing.
Roberta, you'll get my phone number with this paperwork from the court, so you can call my office. Should have discovery and an offer probably by next week, so I'll be hopeful to see you by the end of next week.
Okay.
Okay. Mr. Sowards, you ready on Mr. Fackler?
Fackler, Your Honor, is available.
All right, Mr. Fackler, can you hear the court, sir? Mr. Fackler, could you state your name and date of birth, please, for the record?
Dylan Faulkner, 1990.
All right. Mr. Fackler, your attorney, Mr. Sowards, is with us here in court. Go ahead, Mr. Sowards.
Thank you, Your Honor. It's my understanding that based on Mr. Fackler's unfortunate 2022 arrest and January 9th, 2026 entry of a plea of guilty on a DUI, the prosecution has moved to revoke his deferred prosecution from 2019 here in Battleground Court. We understand the specifics. The recommendation is for a 60-day jail term followed by 90 days of electronic home monitoring based on his more recent conviction, which is actually in the standard, the after conviction. He is currently serving 120 days jail followed by 150 electronic home monitoring. Our request today is have the court review his financial circumstances with respect to a Blazina analysis. He's obviously in custody. He's already been found indigent. We are also proposing that to schedule the 2 jail sentences that are mandatory and the 2 electronic home monitoring periods. Mr. Fackler, his family is in Concrete, so he has a hope that Your Honor will let him finish his Clark County jail sentence, go immediately to Clark County electronic home monitoring, where he can work the rest of the summer. When he finishes his Clark County electronic home monitoring, our presumption is he would then go probably to Skamania for the jail sentence, and go back on the Battleground electronic home monitoring. Unless, of course, the prosecution would recommend making everything concurrent, which would be just lovely.
Concurrent.
Yeah, we didn't think that. But again, the goal here is to get him back to work over the summer. He could address some medical concerns, some dental concerns, candidly, a infected toenail concern that the jail doesn't seem to be handling. But that's our main request, is to allow the 4 separate confinements of Clark County Jail, Clark County EHM, then Battleground Jail, then Battleground EHM. That will let him effectively serve the Battleground jail time fundamentally over the winter when there's not much work for Concrete anyway.
So he entered a plea in January is what you're saying.
January 9th, 2026.
And it was a
district.
plea. It was not a trial.
He pled guilty, Your Honor.
No, I mean, he had 4 years. The case was pending. He created a circumstance with knowledge of these multiple cases.
He was represented during that time by a private counsel.
That's fine. So the private attorney would have let him know that you have a deferred prosecution pending. When he pled in January, it's a statutory requirement that his deferred prosecution is revoked.
That we understand. That's
okay.
Yeah. It's more of the sentencing.
And again, he chose to plead when he pled. So no, the court is not going to accommodate him and release him for a period of time to work and then try to do the jail sanction later. He's going to do his jail in Clark County. He's then going to go to Skamania and do his jail in Skamania. And then he's going to go out on EHM and do his EHM for Clark County and do his EHM for Skamania. There's not any other thing that makes sense. Do you have a PTA for me, Mr. Busby, on this case?
I believe there is one, Your Honor. Give me 1 second. I have it. Oh.
Because of the long term of incarceration, I don't need to do a Blazina analysis. There is no work center. He's going to be in jail for the remaining term of his Clark County case.
Mm-hmm.
He is then going to be in jail for he'll likely go to Skamania, but he will be in jail for that portion. So with the prolonged period of time of no working, I am going to find that Mr. Faulkner is indigent for the Blazina analysis.
And Your Honor, we do have a PTA. I just didn't attach it to when I came out. So my fault, but looks like it's being printed. I don't have it with me. And the printer is closer than where I'm put today.
All right. So for the record, I am going to review for probable cause, which is required when a deferred prosecution revocation takes place. So I'm going to do that first. I'm then going to get a pretrial agreement, hopefully from the parties here in a minute from Mr. Busby. We are then going to proceed to sentencing, but first I am going to make a probable cause finding. This is an incident from September 16th, 2019. Taking place in the city of Battleground, Washington. Officer witnesses the vehicle strike a curb as it tries to pull into the Walmart parking lot. Officer made contact. The defendant was unstable, had to brace himself on his truck. Smelled of alcohol, swayed side to side, bloodshot, watery eyes, speech. Admitted to alcohol consumption. Formed SFST's preliminary breath test. Holy cow. 3.3. BAC 315, 313, 322, 325. Court is going to find probable cause for a high breath test DUI. I do have a pretrial agreement. We are going to proceed to sentencing. Madam Clerks, can you hand me a DUI sentencing form, please? Mr. Sowards. Mr. Faulkner, I am going to find you guilty of DUI. Count 1, 364 days in jail with 214 days suspended. That leaves 60 days jail. And 90 days of electronic home monitoring for a total sanction of 150 days. The sentences are to run consecutive with the Clark County case. That is statutory. The jail sanction can be in Skamania County. That is at the discretion, though, of the Clark County Jail. Sentences suspended for 60 months. It'll be a $5,000 fine with all 5,000 suspended. I am finding pursuant to Blazina analysis that Mr. Faulkner is indigent. Substance use disorder evaluation that the court is going to be monitoring can commence within 150 days. It can certainly be the same evaluation treatment plan that is utilized in Clark County. The victims panel has not been attended. It would be attended also within 150 days. I'm going to set a monitoring date out. We will check in, I suppose, in the month of September. I'm going to schedule this for a hearing on the 3rd of September, 2026 at 1:30. That would be reviewing EHM status. If the jail sanction is completed, substance use disorder evaluation, recommended treatment, and victims panel. Anything else from the parties? All right, that concludes your hearing, Mr. Faulkner. Good luck.
Wait, Your Honor.
Yes.
I have an extremely infected toenail that has been told to me with multiple times since I've been in the hospital that it needs to be surgically removed, and it's gotten way worse in here. And I have a doctor's appointment scheduled for the 11th to where it will be addressed, and also a tooth that needs to be removed that I have scheduled for the 7th. Is there any way that I could do those two doctor's appointments, those two appointments, and then go into custody, so I can have this taken care of? I'm meeting with a person tomorrow to get on antibiotics. I need a little, just to these two appointments to go to before I go back into custody for again. If you would please allow me to do that.
You are not serving my sanction right now. The sanction you are serving is from the case that you pled guilty to in January. Okay?
Correct.
You had an on that case in January. Your attorney can file a motion in Clark County in front of the judge that sentenced you. Okay? My case is going to be a jail sanction that you're going to serve after your Clark County case. Does that make sense?
I guess, yeah, but that's why I was asking if you could set the date like a week or two. I'm sorry, I'm not trying to interrupt you.
Yeah, you are. I'm telling you that you're not serving, the jail that you are serving right now is on your Clark County case. Do you understand that? Yes or no?
Yes.
Your attorney that you hired that represented you on that Clark County case can petition in front of the judge who sentenced you in January in Clark County. Do you understand that?
I do.
That judge who sentenced you in Clark County, who you were in jail for right now, serving their sentence, is the judge that could choose to furlough you. Do you understand that?
I do. What I wasn't clear about is that these
Mr. Faulkner, hold on a moment. What Mr. Faulkner did is he scheduled appointments for after his release on the Clark County in the hope that he'd have some time before the battleground incarceration. So his comments are not getting treatment while he's in jail. His comments were that he had scheduled treatment for after he's in jail. I think you've ruled, but I think that I just want to get his position known to the court.
So he's serving, hold on. You told me he's serving a 120-day sanction and he pled in January.
That is correct, Your Honor. 120 days. And according to Mr.
That does not work out mathematically because there's no good time on a DUI case.
Yeah. Just according to Mr. Faulkner, his position was he had made these appointments in May for when he believes he'll be out of custody on Clark County District.
The math does not work. If he pled on the 9th of January and he's serving 120 days, and it has to be 120 days because it's the mandatory minimum on the 11th of March, he's still in custody on the Clark County case.
His appointments, he told me his appointments were in May for that particular reason.
If his appointment is in May,
I don't think Your Honor's
he's not being seen by jail medical now. I'm not going to release him for something prospectively in May.
I think you made your ruling. I just want to get his
Clark County case ends and he's in Skamania County. I'm always fine with signing something if the medical folks assess it, but I'm not releasing him in May prospectively right now at the beginning of March.
Understood, Your Honor. I just wanted to make sure he got his point across.
I understand. Okay.
It doesn't make any.
Zane Phillips, if I could have you unmute and turn your camera on, sir.
Hello, Your Honor.
And have you state your name and date of birth, please, for the record.
Zane Michael Phillips, July 25th, 1993.
Having a bit of a connection issue, so go ahead and turn your camera off now. Expected you to be in person today, Mr. Phillips. And at 8:30 this morning. Different issues, it seems.
I thought my appearance date was for Friday at 1:30 in the afternoon, but I checked the docket and it said 10:02 this morning.
Well,
and I'm doing my best to get there, but I obviously couldn't.
Well, you're going to be in person at your next court date. We had previously assigned Mr. Sowards to your case. You didn't come to court in September of 2025. You had a new protection order conviction, and you have 15 days of work crew in Battleground you haven't done. So the next court date will be in person. It's going to be on the 2nd of April. I'm going to reassign Mr. Sowards to your case, and if you don't show up in person, I'm doing a book and hold warrant. Do you understand?
I understand what you're saying, but I don't understand what I'm getting charged with. I settled all this stuff. I don't have a protection order with anybody.
You did settle this stuff, and you got a 15-day work crew sanction. You didn't do any work crew. So that's what
I've been sick.
Not doing any work crew. Not doing any work crew since February of 2025 for over a year. No work crew. And then you had a return court date and you never came back. So that's exactly what we're doing today. Do you understand?
Yes, Your Honor.
So in the meantime, after you pled guilty to a protection order case that you were convicted of. So yeah, you have a new criminal charge and 15 days of work crew you didn't do. And if you don't show up on the 2nd of April, I'm going to put you in jail. Do you understand?
Yes. I've been in jail about a dozen times for this thing.
Okay. Well, it might be number 13 then. So please show up for court at.
Sounds like you want me to be in jail, man. I'm doing my best here. I'm homeless. I have health issues.
Single thing that you were sentenced to do, not one, and you have a new criminal violation. So at this point, I don't know anything. You were supposed to be here and in person today. I'm giving you the opportunity to have an attorney. I'm giving you the opportunity to show up on your own and show the court that you don't want to be in jail. So that's the opportunity you're getting today. Do you understand?
Yes, sir.
That's where we are. I don't care about whether you're in jail or not, but I'm giving you the opportunity to do the thing that you agreed to do when you pled guilty in February of 2025. That was the responsibility and that was the deal that you accepted. Do you understand?
Yes, Your Honor.
All right, we'll see you back April 2nd at 10 a.m. That's your next court date. I'm assuming that we do not have a mailing address for you if you're unhoused.
I do have a mailing address. It's my brother's.
Okay. What address would you like the court to send paperwork to? Got it. Okay, we'll send documents there, Mr. Phillips. We'll see you back on the 2nd of April.
Okay. Thank you for your time, Your Honor.
Log out.
Thank you. All right. Let's go on the record in the matter of Leanna Edwards, 25845D. All right, counsel, your appearance, please.
Good morning, Your Honor. Your Honor, John Goldclaw, P 30758 on behalf of Ms. Edwards. Ms. Edwards, please put your name on it.
Leanna Edwards. All right, thank you. This is also count B as well. And so today's the date scheduled for a probation violation. Your client is on probation for possession of drug paraphernalia and operating while visibly impaired. And it's alleged that she tested positive for cocaine on January 27th, January 23rd. There was a tether tamper and positive for alcohol on February 12th.
Excuse me, Your Honor. I believe that you said January 27th and January 23rd.
I meant February 23rd. Yes, thank you. Yes.
Correct. And there was also a
tether tamper, and positive alcohol
On the 20,
on February 12th.
February 12th, correct?
Yes. Yes. And so counsel,
Your Honor, I had an opportunity to speak with Ms. Edwards. I've explained to her what the allegations were. I've also explained to her what the recommendation is. I've also explained to her that she does have a right to a hearing on these matters and understanding all of that. This time she would plead guilty to the violations. However, Your Honor, as to the recommendation, we would be addressing that.
all right. Ma'am, please raise your right hand. The other right hand, please. Thank you. A lot of people do that. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
And you heard the allegations, ma'am, correct?
Yes.
As to those allegations, how do you plead?
I plead guilty with an explanation.
And you've gone over your advisory rights for probation violation purposes, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand that you'll be waiving some of those rights by entering into this plea.
Yes.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
And knowing all of that, do you want to continue with your plea? Has anybody promised you anything?
No.
Threatened you or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please vote your client.
Thank you. Ms. Edwards, back in October of 2025, you were placed on probation to this court. Is that correct?
Yes.
And some of those terms and conditions were that you were to test for drugs and alcohol, and that you were not to consume any alcohol or prescription drugs that were not prescribed. Is that correct? And that you were to test for those on a regular basis. Is that correct? And did you test positive for cocaine on, January 27th of 26 and February 2nd of 23rd of 26?
Yes.
And is that because, and I'm sorry, and you have a medical marijuana card, is that correct?
Yes.
And did you smoke marijuana on those days?
I did.
And where did you get the marijuana?
I had got my marijuana from a dispensary, and my friend, I guess she got it from a dispensary. I didn't see her roll her blunt.
But so you smoked marijuana from her blunt, is that correct?
Yes.
Why didn't you smoke it from his own?
I did match.
Did what?
Blunts. We matched blunts. She got a blunt, I got a blunt. We smoked it at the same time.
Okay, and now, all right, I understand. And was that on the 27th?
As well.
And you did that on the 22nd?
Yes.
Right. And as far as the interruptions of the tether, on February 12th, 26, can you explain how your tether was allegedly was obstructed? Or
We cooked dinner that night, and my fiance had a wine glass and a wine bottle. He opened the bottle and was pouring, and he dropped the bottle. And it went in. I did not consume no alcohol.
Did you?
Just gonna go all over your tether?
Yes.
And then you cleaned it up and then.
I cleaned it up. That's how I got in between the tether.
That satisfies her.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the violations, indicate technical violations. 3 through 5 will enter. Let me ask a question, please. What time were you cooking dinner?
I took dinner about 7:30 that night.
PM?
Yes.
Okay. And I asked that because the obstruction and alcohol detection is between 5:28 a.m. and 12:35 p.m. outside the times of this wine spill. I can't hear you.
I'm sorry, you said what time?
I said that definitely cannot be because I was inside the grocery store around that time.
At 5:30 in the morning?
Yeah, not 5:30 in the morning. I go in at 6. I do Instacart as well in the mornings.
Okay, well, it's saying that the confirmed obstruction is from February 12th at 5:28 to February 12th at 12:35 PM.
I don't know how, ma'am.
How long have you had your medical marijuana card, ma'am?
I had it since 2020 and got redid last year when it expired.
And that's from a treating physician or just from a random marijuana clinic?
Physician, I have broke my-
Ma'am, please let me finish my question for the record, okay? Only one can get recorded at a time. Or is it from a random marijuana clinic?
No, ma'am, it's from an actual doctor. I have broke my arm in 2020.
Okay, and so you broke your arm, it's no longer broken, you had it repaired or fixed or it treated, correct?
Kind of, sort of.
What does that mean?
I never did go back to physical therapy. It still hurts on occasion.
Okay, so for your broken arm, you have a medical marijuana card?
Yes.
Okay. And so when do you use the marijuana?
Almost every day.
But it only hurts sometimes?
Yes.
Okay. So if you need it for medical purposes for your arm and it only hurts sometimes, why are you using marijuana every day?
So I can encounter it, as I said, I do Instacart. So when I'm lifting up cases of water every day, it gives strain to my arm. So I don't want to have to actually keep, when it hurts, it goes into very deep pain.
Okay. So ma'am, there are some concerns that I have with that, right? Because you're driving to go get these groceries to put together for people and you're driving to drop them off or what have you, right?
Right.
And you're using marijuana while you're driving. I mean,
I'm not using marijuana while I'm driving.
and maybe not while you're actually driving, but you're using it and then you're driving. And so you're under the influence of marijuana, ma'am. Just so you're aware, the law in Michigan, right? If there's any of it detected, if you end up getting in a car accident or pulled over, whatever it is, ma'am, if there's any detected, that's a problem. So you need to really familiarize yourself with the laws in Michigan regarding marijuana use and operating a motor vehicle.
Okay.
Okay. But besides that, your client is now tested positive for cocaine twice.
And she indicated to me the circumstances, as I've indicated, she was with her hairdresser.
Yes.
On both occasions. As she indicated to me, had she known of the first violation on the 27th, prior to the 23rd, she would never have shared the marijuana with her hairdresser.
Okay, just a moment, please.
I'm not.
Just a moment, counsel. Ma'am, do you recall when you were here on January 6th?
Yes.
This court ordered mandatory revocation of under advisement status for any future violations and 45, that was 45 days. Yes, mandatory revocation of under advisement status for any future violations. So if you wanted to keep that status, ma'am, you needed to make sure that you were being more particular about your marijuana use. I don't know why
I understand.
I guess I don't understand if if you each have your own cigarette, why share? And it doesn't even make any sense to me. However, that's not really for me to understand. What I do understand, ma'am, is that you have now violated 3, 4, and 5 times on these violations. You have been on probation since October, and you now have 5 violations. That's November, December, January, February. So In 4 months, because all of these occurred by February, in 4 months, you have 5 violations. What's that, 1.2 average per month?
Of the surroundings on, yes.
Man, that's in your control. That's in your control. So were you with your hairdresser twice? Is that what it was?
Yes.
Both times?
Yes.
How often do you get your hair done?
The hairstyle I got it every 2 weeks. But because I had to pay this last time with the tether, I couldn't to pay him. Well, I had to pay the tether.
Okay, well, counsel, I was very clear, under advisement would be revoked. And the recommendation is for your client to be tethered to treatment and revoke probation. And it seems as though with your client averaging 1.2 violations each month while she's been on probation, it doesn't seem as though your client is a candidate to continue probation.
Your Honor, if we could, I understand that well, tethered to treatment would be appropriate under these circumstances. However, Your Honor, I believe that if that occurs, then she'll be losing her employment. And we're asking rather than tethered to treatment, just place her on tether, continue testing for the 60 days and
Counsel, your client knew what the possible penalty was for violating.
I understand, Your Honor.
And so it's an unfortunate consequence if she loses her income. However, this court had conditions in place.
I understand, Your Honor.
And your client did not follow those conditions. This court gave her an opportunity at the last probation violation hearing, which was just January 6th. And within 5 weeks, she had already violated 3 more times. So no, counsel, the court is going to adopt the recommendation. The court's going to order under advisement status to be revoked on count B, probation to be revoked, cases on both counts, cases to be closed without improvement, $50 probation violation fee, 60 days jail, tethered to treatment. All right, ma'am, you're going to be going through this door.
Thank you.
Good luck to you. Make sure you drive your pockets, ma'am. The court will note that the 60 days is concurrent with A and with B and D. They're concurrent with each other, so the total is 60 days. Okay, there we go. All right, let's go off the record for a moment. All right, let's go on the record in the matter of the State of Michigan versus Dylan Quitter, 251659.
Good afternoon, Your Honor. Attorney Jonathan Paul for Mr. Dylan Quitter. Good to see you, staff.
Good afternoon, counsel. This isn't scheduled until 1:30. I'm prepared to handle it now, but the victims in this matter were notified for 1:30. And I think from what I recall reviewing that there was not going to be anybody appearing.
No, Your Honor, that was my understanding.
Okay, so we'll continue.
Thank you, Your Honor.
All right, Mr. Quitter, your name for the record, please.
Dylan Quitter.
All right, thank you for dressing appropriately for court this afternoon. Today is the date scheduled in this matter for sentencing on your client's plea to an amended charge of malicious destruction of property, $200 to $1,000, larceny, $200 to $1,000, and attempt resisting and obstructing. Those were all reduced from the original charges of malicious destruction of property, $1,000 to $20,000, larceny, $1,000 to $20,000, and resisting and obstructing.
Yeah, Your Honor.
All right. And so counsel, as to the report and recommendation, did you have an opportunity to review that with your client?
Yes, Your Honor. Your helpful probation staff sent that in advance, which I kindly appreciated. My client had a chance to review that as well. We've had conversations about it. We believe it to be accurate and ready to proceed to the sentencing, Judge.
Okay, so, Mr. Quitter, I gotta tell you, I'm not really sure what came over you that day, sir. at all. I mean, who climbs on top of cars and jumps on them? There was a communication that that the court received from one of the victims, and asked if the court would read it. And so the court will do so. All right. This was on February 11th. To whom it may concern, I am submitting this statement regarding the damage sustained to my vehicle during an incident at Whiskey's on the Water involving Dylan Quitter. I think that more appropriately, it was the parking lot behind the establishment, correct?
Yes.
Okay. Which is the city, one of the city public lots. As a direct result of this incident, my vehicle sustained significant damage. This included severe damage to the exterior mirrors, forced entry into the interior of the vehicle, and damage to windshield wiper components. The interior was disturbed and additional structural and cosmetic damage occurred. The total cost of repairs amounts to several $1,000s. These damages were not present prior to the incident and required repair in order to restore the vehicle to safe and operable condition. The financial impact has been substantial. I respectfully request that the court consider this statement when determining restitution in this matter. Thank you for your time and consideration. Sincerely, and it's signed Ms. Smoke. So I know that there was restitution paid in the amount of $3,721.45.
Yes, Your Honor.
But that was paid to,
It was for all parties, Your Honor. The detective collected the check from both parties for the exact amount halfway at the plea.
okay, that wasn't my question. My question was as to which victims did that represent?
All of them, Your Honor. That's what Mr. Muhammad asked for as part of the plea.
So Mr. Mohammed, your appearance for the record, is he there? I thought he was just, oh, there you are, sorry.
Good afternoon, Your Honor. Muhammad.
And so Ms. Moak's statement that she sent into the court would indicate that the cost requires or amounts to several $1,000s. And it's also my understanding that victims Henderson and Williams have been paid in full for restitution, but not as to Ms. Moak.
So Judge, the victims on this case that were willing to cooperate with our office were made full with restitution. Any other victims or witnesses did not want to move forward, was my understanding. And so I reached out multiple times to different victims on this case, confirmed, well, I don't know if it was me specifically, but my office did, and we confirmed the total amount of restitution. We discussed the plea with them, and yes, everything's been satisfied as far as the plea. If there's I'm sorry I wasn't here when you were going through the other victim's statement, or maybe wasn't listening, but there's another victim that's indicating that they're missing on restitution. It's due to them not wanting to proceed at an earlier proceeding in this case.
She's not indicating she's missing restitution, counsel. I just want to, she's indicating that she's out several $1,000s to repair her vehicle. So she's not indicating she's missing restitution. She's not indicating that. What I am focused on is that Mr. Quitter entered into the plea for restitution including paying restitution in full for 2 of the victims. That restitution was paid in full, but there is one of the other 5 listed victims in this matter has indicated that there's several $1,000s that is going to cost to repair her damaged vehicle.
Judge, in regards to the vehicle, we did have a estimate and it's been satisfied. I don't know, I'll need to go through all the list and see which victim specifically is making this statement and cross-reference it with the check that's been turned over. It's my understanding full restitution has been satisfied.
Yes, let me clarify again. For victims Henderson and Williams, the restitution has been satisfied. There's a third victim that wasn't included in the computation of the restitution. And I bring this up because Mr. Quitter may have to pay additional restitution for this victim for the damage to her car. So I don't know if that's something that you want to explore with the prosecutor before we proceed with sentencing, or if you want to set it for a restitution hearing, or how you want to handle that.
Yes.
That's why I brought that forward.
In regards to damage to a vehicle, my understanding is restitution was completed on that, and so that's why I will need to look into this because I don't know which victim. I don't know if there's multiple vehicles that were. I'll need to look further into. I'm sorry. I will have to look further into this specific incident.
From our perspective, the prosecutor brought us what the restitution was, who needed to be paid. Myself and the other party made those payments, split in half. They complied as part of the plea. But certainly, Your Honor, if there's someone that comes forward that was inconvenienced by my client's actions on that evening, if the person has come forward and provides proof to the prosecutor, certainly the prosecutor can reach out and leave that restitution open, Your Honor. We're ready to proceed on sentencing, but we understand there may be another victim. And if they do have the proper bills and the prosecutor also agrees, certainly my client is not going to not pay that if something was done. So as part of the plea, Your Honor, we have to go forward with that. My client is open-minded that there may be someone out there that may still be at loss, and if they can provide proper documentation to myself and the prosecutor, that's something we're certainly open to, Your Honor.
Okay, that's why I wanted to make sure, confirm on the record that your client understands that there may still be additional restitution that he may be on the hook for with Ms. Moak.
Yes, Your Honor, and if that's provided myself and Mr. Mohammed have a conversation and there's a number and I review it, my client would likely have no issue with that. If it's something that doesn't seem reasonable, we may need a hearing, but I think myself and Mr. Mohammed have a good working relationship. We could certainly work on that.
Yes, and Judge, one of the reasons that maybe Ms. Monk wasn't contacted was because we only had 2 individuals that wanted to proceed on this case, and both those individuals were contacted, and we gathered restitution numbers from both of those individuals. So I will have to look further into the notes. This is the case from some time ago, but from my recollection, there was only 2 individuals that wanted to proceed with this case, and that is what the restitution was regarding. They've now switched their minds. That's something we're gonna have to take into consideration, but there's no guarantee that we can now go back in time and change the plea agreement to include them.
I'm not.
And I know the court's not suggesting that, I'm just placing it on the record, so there's a record as to what was done and why it was done.
So was that communication by your office with all 5 victims, or was that through the detective?
Again, I will have to go through the case. This was from some time ago. I normally don't appear at sentencing hearings. This was kind of just on the whim.
Right.
As I was sitting in the courtroom, I will have to go through the case file and pull up the notes. And then I can provide more information as to what the basis of that was.
Okay.
I do recall with certainty that there was a number of individuals that did not want to move forward with this case, and 2 specific witnesses that did. And again, this is just from recollection. I haven't reviewed the case in some time.
Okay, and I will state as well that this indicates according to, so victims' rights letters were mailed to all 5 victims from our probation department per the Crime Victims' Rights Act. Victims Henderson and Williams have been paid in full for restitution. That was all part of the plea, and that's what happened prior to the plea even being entered. According to Detective Carr, no other victims were requesting restitution. Elizabeth Moak did respond to the letter that I sent, and she asked the court to consider her email when reviewing restitution, though no amount was requested. So she states that there is thousands of dollars, doesn't have a specific amount. So there may be a restitution hearing that has to be scheduled for that one. It's possible that when communication was made by the detective that she was out of town, I don't know, but just not having made that contact or connection this court will not preclude her from being made whole as much as possible from your client's actions.
Understood, Your Honor. And Ms. Moak reaches out to the court and the prosecutor's office. Both parties are very capable of receiving her documentation And if she does have documentation of those damages, Mr. Muhammad could certainly reach out to me, provide me that documentation. And if my client is agreeable, then we won't need a hearing, Your Honor. So we're very open-minded to Mr. Muhammad reaching out as the party for this individual.
Okay, all right. And so with all of that, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds that Mr. Quitter, that the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter.
May I speak on behalf of my client before you sentence him?
Of course not. No, you should, Ray. Sorry.
Thank
I got ahead of myself. Yes.
No, I understand, Your Honor. And thank you, Your Honor, for bringing that to my attention. One of the Mr. Quitter and his family from the very beginning did want to make everyone whole. That's why there's no objection to that. If there's money that's due, they certainly want to do that to make things right. Because from the last 4 months, Your Honor, 5 months, Mr. Quitter's been taking this very seriously. As you can see from the report, there was a lot of intoxication on that evening. He certainly made a very poor choice while intoxicated. He has been working with a counselor on that. He did a substance abuse assessment. He's been working with a counselor specifically on that, Your Honor. So at his young age, understanding that alcohol can take you out of your best judgment and turn you into a monster for a couple hours, Your Honor. And for those hours, he was not himself, but he is back to being himself. He has a 3.88 in finance. In college, he's about 20 credits away from graduating. He's working part-time at Meyer. He's done community service 25 hours at Forgotten Harvest. So every single day, Your Honor, he's put his best foot forward to make up for his poor choice in that evening. Both mom and dad are extremely active in this case. Dad is here today. I've had numerous conversations with them. So when talking to Mr. Quitter when he arrived today, I said, we're in a much different place today than we were in November. Where in November, he was sitting in a jail cell, sobering up and realizing what had happened and not remembering a lot of it. So much better place here today, March, a lot to look forward to. So we're going to ask the court to adopt the recommendation, allow Mr. Quitter to go on probation, to continue his journey moving in the right direction. And as noted, Mr. Quitter has no objection if additional restitution comes forward with the proper documentation.
Okay. So, Mr. Quitter, I acknowledge that you have been putting your best foot forward since your arrest. I'm not sure if you realize even some of the collateral consequences as a result of your actions. There was one individual who was working an extra job to earn some additional money for Christmas gifts for his children. Well, that was one of the cars that you damaged and items that you stole. I'm having a difficult time understanding, sir, how the consumption of alcohol, 8 to 10 beers, okay, how that then translated over to the behavior that you and Mr. Hills exhibited that night. How does that even come to be?
We just took it way too far, and I don't understand how it happened to me.
Right. I mean, you're telling me you're telling me the known, right? That you took it way too far. Clearly, because you're here and there's 5 victims on here. How did we get here? Where's the how?
I just was out drinking with friends, and we just kept going and going and going, and not taking into mind what the exact consequences are for just not thinking about what we're doing and just go.
So you were drunk, leaving the bar, you go out in the parking lot, and you just start walking on top of cars? Is that just, you start walking on top of cars, or did you and your buddy pick a couple cars and jump from car to car? I mean, what happened?
From that situation, I really have no recollection of how that choice came to be.
Do you find that scary? Well, one good thing is at least you were arrested before you got in a car and drove home, right? Because if you don't recall all of that, then who knows what would have happened on your way home if you were driving. And if those individuals were here today, sir, what would you say to them?
I would apologize to them that my actions were not excusable one bit and that I've been working to better myself, wanted to make them whole as soon as possible.
And what have you learned in therapy, sir?
I've learned that I've got to learn how to pace myself, learn that my actions do have consequences, and that I need to find better things to do with myself, better ways to kind of give myself entertainment than just going out with friends and causing issues on the weekends.
Okay.
Judge, if I may.
Yes.
I had an opportunity to review the case file for this case, and the case notes by the warrant prosecutor is that she made contact with Brianna Williams and Jeffrey Henderson, and they wish to proceed charges. And the others, then she writes, the others either do not want to press charges or cannot be contacted. And then there was another case note that I think is relevant, and it states that, and this is by the warrant prosecutor who indicated that she spoke with the OIC, and she wrote, he informed me that victim 3, Monk or Moke, and victim 4, Diaz, do not wish to proceed with charges. Victim 2, McGuire, hasn't returned any of the OIC's calls, but will continue to try. So again, that was the basis of why restitution only relates to Brianna Williams and Jeffrey Henderson's, because those are the only 2 individuals that wish to proceed charges at the time the warrant was signed.
Okay. All right. Thank you very much for that clarification. So, but again, that will not negate for Ms. Moak if she wants to
Understood, Your Honor.
request a restitution hearing. Okay. All right. So now the court finds there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Quitter. You are, the court's going to order 24 months probation. You're eligible for early discharge, which I will go over shortly. You're also eligible under HIDA. You are not to violate any criminal law of any unit of government. You are not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition serves so the court can monitor your progress in maintaining abstinence and sobriety. And I think that, never mind. You are to also attend outpatient substance use counseling, which you're already doing, correct? So the court's going to order that to be continued. I'm not going to order you to find someplace else. That would be counterproductive. The rehabilitative goal for that condition is to continue assisting you in providing coping mechanisms so that you can maintain sobriety and prevent relapse. The court's going to also order you to participate in fan meetings once per month. The rehabilitative goal for that condition, sir, is so that you can have additional support in maintaining sobriety as well as recovery resources. You have to participate in an economic crime class. The rehabilitative goal for that condition is so you can understand the consequences of property damage and other financial consequences. You're not to have any contact with the 5 victims, but since you don't know them, that shouldn't be an issue. Not to return to whiskey on the water or any bars. None. Right now, it seems as though you need to get your consumption under control and your inability to make rational and reasonable decisions while you're under the influence. The court will note that a restitution hearing may be scheduled as it relates to the damages by the victim I read the statement for.
And Your Honor, on that, if there's a number, Mr. Mohammed provides that, it probably so we don't need to hear it.
Okay.
The goal is to make it more whole, Your Honor, as long as there's documentation. Thank you.
The court's going to also order you to participate in a making decisions class, sir. The rehabilitative goal for that condition is so you can further understand the consequences of the poor decision-making that occurred and what that could be moving forward if you continue with those poor decision-making processes. Any questions regarding those conditions? Okay. As it relates to the charge of malicious destruction of property, 750.377. I'm just looking, counsel, to see what the,
Fine is,
yes.
thank you, Your Honor.
Sometimes they're $100, sometimes they're $500, sometimes. So, I just want to make sure I have that correct. Okay, well, you won't like this. Fine of not more than $2,000 or 3 times the amount of the destruction, whichever is greater. So, what I'm going to do, sir, because you have multiple accounts, I'm not going to go with the max fine. Okay. I'm going to go with $1,000 fine, not the $2,000 fine, or the 3 times the maximum, or 3 times the value, whichever is max, which I think is 3 times the value. $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 24 months. Since you're eligible for early discharge, up to half of that could be waived. Cost of prosecution, $400. Crime victim assessment fee of $75. Justice system assessment fee of $50. So that total, sir, is $2,825. As restitution's already been paid, I'm not including restitution. That would just muddy the waters to say this is the restitution and it's already been paid. As to count 2, which is MCL 750.3564A. Okay. If the value of the property is more than 200, less than 1,000. Oh, it's the same. Oh no, wait, $200 or $1,000. Oh, it's the same, $2,000 or 3 times the value. Okay. I'll go with the $1,000 fine. I'm not going to assess a screening and assessment fee. I've just assessed that on the first count. $200 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, total $1,325. As to count 3, attempt R&O, the court's going to order a $500 fine, $200 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. That's total of $825. The total between all 3 cases, $4,975. I know that's a lot of money, sir. When you go over to probation, you can set up a payment plan. As I did indicate, you're eligible for discharge as long as all of the following have occurred. You complete at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay, sir? All right. Good luck to you, sir. Please have a seat in probation and somebody will be with you shortly.
Thank you, Your Honor. Always a pleasure to see you. Thank you for your time today.
Have a good day.
Thank you, your staff as well.
Thank you. Let's go on the record in the matter of the state of Michigan versus Todd Steiger, 251646, and the city of Wyandotte versus Todd Steiger, 251304. As to representation for Mr. Steiger on the state case, that's you, the state case, that's you.
Oh, as to the representation, I was waiting for you. I thought you put your appearance on the record.
I was just letting, yeah. Okay, put your appearance on the record.
Good afternoon. It's been a long morning. Good afternoon, Your Honor. Michael Kettner here on behalf of Mr. Steiger.
Thank you.
And as the Wyandotte case, John Goldpaw, P3075, on behalf of Mr. Steiger.
Thank you. And Mr. Steiger, your name for the record.
Steiger.
Okay. All right. So today's the adjourned for, it's an adjourned bond violation hearing as well as a bond violation hearing, then a preliminary issue as well. So as to the bond violation, it's alleged, counsel, that your client tested positive for alcohol on December 15th of 25, failed to appear for testing January 22nd of 25, December 22nd of 25, January 2nd of 26, January 20th of 26, and February 1st of 26. And so council, are we proceeding with the hearing on those bond violations or?
He's willing to accept responsibility with explanation, Judge.
And that's,
Okay.
that's to the one, that case as well, he would plead guilty to those bond violations with explanation.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. And sir, you heard the bond violations that were alleged, correct?
Yes, sir.
And you, in fact, sir, had bond conditions set on your 251305 matter. You had those set November 18th. And then you had your bond conditions on your 251646 matter on November 26th, correct? Of 2025. And you were aware of those bond conditions, correct?
Yes, sir.
All right. And you said as to those bond violations, you plead how? How do you plead?
Guilty.
And you've gone over your advice of rights as it relates to a bond violation hearing, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
And you understand the possible penalty as a result of your plea.
Yes, Your Honor.
And knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
All right. As part of the penalty, this court could revoke bond, incarcerate you for until your next court date, for partial time or something in between or a combination of all that. Do you understand all that?
Yes, Your Honor.
And has anybody promised you anything, threatened you or coerced you in any way for you to enter into a plea today?
No, Your Honor.
All right. And so, Mr. Pecknick, I'll have you proceed with voir dire first.
Mr. Steiger, I think we're about to move things here, but
I'll need you to speak directly into the microphone, please. Counsel, I need you to speak, you're much more quiet. So I need you to adjust the microphones just so she can get you everything on the record.
there, how's that?
Yes, thank you.
Mr. Steiger, at the time that you were on bond in December, did you consume a substance that ultimately turned out to have alcohol in it?
Daquil.
Okay. And you knew that the court had prohibited you from having any alcohol whatsoever?
Yes, sir.
And there were some testings that you were responsible for making sure you attended those tests? So did you miss some of those tests?
Yes, sir.
And the dates of those tests are that you tested positive for alcohol was December 15th of 2025.
Yes, sir. Yes, Your Honor.
And the ones you failed to appear for, December 22nd of 25, January 2nd of 26, January 20th of 26, and February 1st of 26, correct?
Yes, Your Honor.
All right. The court does find the plea as knowing, voluntary, and factually accurate. And the court will accept your plea to the bond violations in that matter. And Mr. Gopal?
Yes, Your Honor. As to the bond violations in that case, Mr. Steiger has pled guilty to those violations. I've been dealing with Mr. Steiger throughout these proceedings. In fact, I did the original.
Well, hold on. So he has bond violations on both cases.
Well,
So I need you to do the voir dire for the city of Wyandotte case.
I thought Mr. Petty was.
He did it for the state case.
I thought it was fine.
Procedurally correct, procedurally cleaner to do it the way I'm asking you to do. Okay, thank you.
Before. Yeah, Mr. Steiger, you had bond violations, correct? And one of those bond violations, one of those bond conditions was you were refraining from alcohol, scrap drugs, etc. Correct?
Yes.
And you were also supposed to be testing on a regular basis when your color came up. Is that correct, sir? And
I can't hear you, sir.
me talking.
Mr. Steiger.
Yes, sir. Okay. And you tested positive for alcohol. Is that correct?
Yes, sir.
And that was because you were on Dayquil?
Yes, sir.
Now, why were you taking Dayquil?
I wasn't
Prior to the date that you tested, were you out, were you sick?
I was sick, and I went to a doctor, and
Pardon? And they prescribed you certain.
they prescribed me certain medications because I had bronchitis, acute bronchitis, and they had a couple other names for it.
And did you comply with what they told you? And did it help you?
No.
Okay, so you took the NyQuil?
Yes, sir.
And you knew, did you know that there was, you knew there was NyQuil in the medicine, alcohol in medicine?
I didn't know until after the fact.
But you still took it because of your medical condition?
Yes, sir.
And you missed on 4 dates, is that correct?
Yes, sir.
And why did you miss those 4 dates testing?
Honestly, I've been working and I've been just trying to do better and just handle my responsibilities. So
And one of those responsibilities is to, when your color comes up, to try and get, you have to get to those tests, is that right? And have you been testing since you missed those tests?
Yes, sir.
And have there been any missed tests?
I don't believe so.
Okay, and have you tested positive for any type of drugs or alcohol since?
No, sir.
Your Honor, I believe that as to the alcohol in his system, we have documentation that he did see the doctor. He had the bronchitis. Unfortunately, and I know there's alcohol in certain medicines, but you have to be aware of that. He was not aware of that, and it was not an intentional violation. It was a violation, and I agree with that. As the testing, I believe that he is getting his act together, so to speak. He has not gainful employment. He's scheduled for sentencing on this matter. I believe this spoke with Ms. Shine, and though it was set for the 20th of February, because of bond violation, that was changed. And it's now, I believe, April 2nd. He understands what he has to do. He's taking those steps. He is living with his grandmother. He's helping her. He understands what drugs can do. He's seen it happen with his mother. I hope the court would take all of that into consideration. His actions were not to flout this court's orders, but make sure he could do what he could do, try to get everything straightened out in his life. I do know he still wishes to, at some point in time, enter the military, at least discuss that at some point.
Okay, so remember I had spoken about a statement that had been made. I wasn't losing my mind. I did find it. It was in a supplemental report.
Oh.
Yes. So about the issues that had been, that Graham had been dealing with.
Oh, yes.
Yes. So, okay, so where is the documentation that your client was ill? Is there anything else you'd like to offer, Mr.?
Yes, I will, Your Honor. He got
me.
Well, he's working on that. The situation was in December, he started feeling sick. So he started basically trying to treat himself. Counter medication, things like that. When that ultimately proved to be unsuccessful, he went to the doctor who diagnosed him with an acute case of bronchitis, provided him actually the correct medicine to take care of that, and he did it. During that time frame, he wasn't very compliant with showing up to his testing for a variety of reasons. Fitness, additionally, his employment. But once these violations were noticed and counsel, brother counsel and I got involved, we've had a discussion with him to say, look, these are not optional. These have to take them seriously. If you show up there, unless you're dead, type things. And since that point, he has always done it. He hasn't had any more misses. Additionally, he's gotten the job at 7-Eleven. His grandmother's here to support him in that relationship. I think he understands, that family understands probably more than us, the impact of serious drug use, given that his mother, his grandmother's daughter, suffers from a severe heroin addiction. And the knowledge of what that can do to you, combined with, for lack of better words, his near miss here, I think it warrants a scolding, but I don't think that anything past that is really going to be productive in terms of, helping him he's on that path. He's just started down it. I just don't want to see him get knocked off of it. I don't know if 7-Eleven is going to be forgiving if we throw him in jail. At least I think he loses that job. And
Okay.
can he get another one? Yeah, but you want to read and stay there, the better it is.
Okay, Mr. Steiger, are you chewing gum right now?
Yes, sir.
Okay, there's a tissue underneath the podium there. Okay,
Sorry.
that's okay. So this documentation is dated December 27th. And your client missed on December 15th, he was positive for alcohol. And the 22nd, he didn't appear for, so, but this isn't prescribing NyQuil or otherwise, but Mr. Steiger, do you recall when you received your instructions for random testing that you are to review the ingredients in anything that you're going to be ingesting, whether it's mouthwash, medication, otherwise?
Yes, sir.
Okay. So to claim that you didn't know NyQuil had alcohol in it, sir, that's your responsibility to read
Yes, sir.
the bottle with the ingredients. And I'm sorry, why didn't you show up for the tests?
I've been working. I could show my work schedule and everything.
Okay, what shift do you work, sir?
I work all different shifts. I work midday, morning, I work midnight sometimes.
Okay. And so are you aware of the testing hours?
6 a.m. to 9:30 and then I believe 5:30 to 7.
Right. So your schedule flexes. As your schedule flexes, then so does your testing times, whether you go in the morning before work or you go in the evening after work.
Yes, sir.
And so since February 1st, have you missed any tests?
I don't believe so. I just tested on Sunday.
Okay. And so, would there be anything that shows up in your system from Sunday?
No, Your Honor.
What about today?
No, Your Honor.
And so how are you feeling?
What do you mean?
Well, since you're not using substances, how are you feeling?
I'm a little more clear-headed. Just wanting to do better, Your Honor.
Okay. All right, so here's what I'm going to do. I'm going to order 10 days jail on each of these. I'm going to suspend the jail. That means, sir, that if you have another violation along the way, then that 10 days is back on the table.
Yes, Your Honor.
But for now, you can continue what you're doing.
Thank you.
All right? You're welcome.
Thank you.
Okay, so that concludes the City of Wyandotte case, and then Mr. Picnic, I need Mr. Mohammed here for the state case.
He was for this second.
Let's get him as bad as Mr. Goldpaw, who needs a little tether on him.
Pardon? Yeah, we can look. Get in there. This guy's in the back.
This turned into a gaggle.
Yeah.
What's that?
This turned into a gaggle.
Yep.
You handed it to him. It had a
Neil.
cross on it.
There's Neil.
I'll tell you.
Okay,
Neil.
okay, and if I wasn't clear, Mr. Steiger, bonding conditions are continued, so you continue with your testing, okay? All right. Okay, and so now we're on the record only in the matter, we're handling the probable cause conference, we're handling a hearing for 251646.
Yes, and good afternoon, Your Honor, Mohammed on behalf of the people.
We'd like to get here on behalf of Mr. Steiger, stands by last. Mr. Steiger, tell us your full legal name, please.
Cameron Steiger.
Okay, thank you.
And Judge, I believe today is the day of the sentencing, but prior to today's date, prior to the sentencing day, my office was received by the OIC of a MSP lab report, which reflected that the drug in this case, which we believe was Xanax, actually came back to test negative for Xanax. And as a result of that MSP lab, we are motioning this court to set aside the plea and dismiss this case.
Defendant does not object, Your Honor.
All right, and counsel, as I indicated, in chambers, and I'm just going to put on the record, if there is a motion to set aside a plea, then it must be put in writing moving forward.
Understood.
Okay, based upon the motion by the people regarding or to set aside the plea based upon the lab reports from Michigan State Police, the court will set that plea aside. All right, and then counsel, you're asking to nolle pros?
Yes, nolle pros in the interest of justice. Thank you.
Okay, so Mr. Steiger, let me be clear, all right, because the way I understand it, you bought these pills presuming they were Xanax and they turned out to be fake. And so your original charge of possession of controlled substance was amended to be an attempt to possession of controlled substance, and which appears to be what it is that occurred. The Wayne County Prosecuting Attorney's Office has taken the position that this matter should be set aside and nolle prost, and if it's chosen to be refiled, it can be refiled. Do you understand that, sir?
Yes, sure.
All right. So, sir, let me just say this, right? You were duped by your drug dealer, so to speak, right? One reason number 2,722 not to buy drugs illegally or use them.
Yes,
All right. All right, the motion's granted on that matter. So what I'm going to do is I'm going to
Judge, just
indicate hold on, please, that the bond posted will transfer to the 251304 matter.
Bond's going over your sake.
Yes. And then obviously the 10 days jail on this matter goes away, but not the other matter. Okay? Yes, counsel?
Judge, just to confirm, this case would be dismissed without prejudice, so our office would retain the right to reissue the charges, depending on whether or not this case is resubmitted to our office, correct?
Correct.
Yeah, that's our understanding as well.
Okay. Thank you. Have a good day.
Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
All right, good luck to you, sir.
That's your job.
All right, have a good day.
Oh, yeah. Have a good day. Ladies and gentlemen, thank you so much for hanging out with me tonight. The last case there with DeSanto, I don't see a lot of those where they come in, they make a plea. He made a plea. I guess, to be fair, he thought it was something that it turned out not to be. So that's the reason they did the nollie pros. You know? No Simpson tonight. No Simpson tonight. Maybe later. Oh, man. Ladies and gentlemen, it's been fun. I'm your Lone Wolf Usul. I'm your host for these here little get-togethers, these little chats about court every single night of the week. We do this same Wolf time, same Wolf channel. That's about 8 p.m. Central Time, 9 p.m. Eastern Time, somewhere around in there. We got lots of friends, Colin and Hutch and everybody else who's out there streaming, doing a little bit the same type of stuff. And speaking of Hutch, we're going to redirect right over into a live stream he has currently in progress, ladies and gentlemen. So thank you very much for hanging out with me tonight, and we will see you tomorrow evening, and hopefully on Saturday I'll be here. I hope I'll see you too. we'll be doing another live stream just like this one, reviewing all the greatest cases from the week. And ladies and gentlemen, for now, I want to say thank you for hanging out with me. I am your Lone Wolf Usul, and I am out. Oh, by the way, Wixom and a few other people donated some money last night, and I didn't say thank you to them. So thank you everybody who watches the ads and participates in chat and sends super chats and all that type of stuff. You people are the hero of the channel. I love you very much. Thank you. Now go watch Hutch. Have a good night.